Meet me at 1. Meet me at 1 when I'm done.
Adjournment request, if any, from item number 1 to 7. From item number 8 to 16. 1 to 7.
Yes.
To mention item number 6, Your Lordship.
Yes.
Your Lordship, due to my viral infection, I could not prepare my matter properly, Your Lordship. So,
As your MS Deka,
G. Bora, Lordship.
G. Bora,
Lordship.
as prayed for by MSG Bora Learned Advocate for the petitioner, re-notify, for the appellant applicant, re-notify on after 3 weeks. Give a date, set a calendar in such a way that it's not known in the group. Set a calendar, 3 weeks, but you have the option. Yes.
29-8. From item number 8 to 16, adjournment request. From item number 17 to 23.
Please, Your Lordship.
Yes.
Lordship, with the consent from the other side, I beg to mention item number 18, as my senior Mr. S.K. Mehdi is
As
out of.
jointly prayed for, re-notify on for up to 2 weeks.
Look, this is a fresh matter. I am appearing for the caveator.
In item number 18.
Yes, my lord.
Yes.
There is some urgency in the matter. This is a fresh matter, my lord. Maybe taken up in the next week, my lord.
On 11th of August.
It will be
if
difficult.
possible.
So
I understand, my lord. As per your convenience, any date in the next week, my lord.
2 weeks. Next week, we are tied up. There's some function at Eton.
I know, my lord.
So
I know.
therefore, let it.
Can it be on next week, Friday, my lord?
No, it will be next to next week, second day.
Next Monday, my lord. Much.
Monday or perhaps
Next to next week, Monday, my lord.
next. All right.
Highly.
18-8.
May I please, Your Lordship, with respect to item number 17,
Yes.
on last occasion, we have to clarify that how the 2 writ appeals have been filed against the same impugned order.
Yes.
So, Lordship, I required 4 weeks time to file our affidavit and bringing on record some documents to clarify the issue.
Nothing more is left. I mean, the petition has been dismissed, no?
Read up dismissed by the Korean bill.
The issue remains the same.
Lordship.
Perhaps this is the case where the appeal was filed by, I mean,
Defense.
the respondent was, who had filed the appeal? The Ministry of Defense. Ministry of Defense, and now this is Ministry of Defense.
This is by the
Anyway,
Home
he has prayed for, on behalf of the appellant / Union of India and others, re-notify after 3 weeks.
Much obliged.
1-9.
May I please, Your Lordship? Lord, I beg to mention a fresh item, item number 20, my lord. Lord, can it be taken up next week or any other convenience?
As prayed for by Mr. A.R. Bhuyan, learned advocate for the appellant, re-notify on 2 weeks.
27-8.
Mine. Obliged.
From item number 24 to 34, adjournment request.
May I please, Your Lordship? My lord, in respect of item number 26, my lord,
Yes.
we have filed a rejoinder affidavit yesterday, my lord, and I have inquired, my lord, it is not tagged with the record, my lord. Lord,
Item number, this is item number 26.
26 that pushback PIL, my lord.
All right. Mr. Bhuyan, learned advocate for the petitioner, submits that rejoinder affidavit has been filed only yesterday, which has yet not tagged with the records. Let the case be listed on so-and-so day with the rejoinder affidavit on record.
Lord, some urgency is there on next,
After 2 weeks,
my lord.
next week, please don't.
No, my lord, I am not insisting on next. My lord.
27-8.
My lord. Obliged.
May I please, my lords? With the consent of petition, I beg to mention item number 29, my lord.
Yes. As jointly prayed for, re-notify 3 weeks.
Obliged.
May I please, Your Lordship? With the consent of the appellant, I beg to mention item 34.
34. Yes,
It may be fixed on 4th of September.
that we can't ensure. You take time, 1 week, 2 weeks, it will depend on our calendar. If a mention has been made on behalf of respondent after taking of consent from the council for the appellant for adjournment of the case. Re-notify 3 weeks. Apply.
5th of September. Adjournment request from item number 35 to 45.
May I please? My lord, I'd like to mention, my lord, item number 39, 40, 41, my lord. These are, my lord, analogous matter, my lord.
All, yes, Lordship.
After 2 weeks, my lord.
Lordship, we have to file our affidavit in reply, Lordship, in respect of the item number 39. Lordship.
All right, you do that within that time. As jointly break for, re-notify after 2 weeks.
Now, can we have a fixed, I'll be for the state response matter.
Yes,
Can we have a fixed date, my lord, 3rd of
Second.
September?
2nd of September.
Date will give.
date will give.
My,
You'll have the date.
2nd of September.
3rd of September. Obliged.
If possible, we shall accommodate, but otherwise we grant adjournment, but dates according to our calendar.
Absolutely.
May it please your lordship. With the consent of the other side, I beg to mention item number 43 and 44.
Yes.
Your lordship, I'm praying for an adjournment in this matter, your lordship.
Calculation.
Oh.
Calculation.
Okay.
As jointly prayed for, re-notify 3 weeks.
Deeply obliged, your lordship.
9 of September. Any other request?
May I please, your Lord? Lordship, I have filed a writ petition, my lord, on 4th of August 2025, my lord, challenging the rules of Assam Higher Secondary Education Service rules, my lord, as well as the advertisement, my lord, regarding Hindi teacher.
That's right. That's on the merits of the case. You have
Yes.
filed it
On 4th of August, Lord,
shall be listed.
on Friday.
Friday, we can't say it shall be listed next week. Give the slip.
Yes.
Give your slip with the number.
Daily list for this item 1.
Wait, leadership.
No, but no, what is the matter? Why has it come for orders? Why has it come for orders?
My lord, it was as per the last order, my lord, some instruction was issued regarding the taking of the steps to 4 and 5, which I have taken, my lord. And to the respondent for taking instruction from the deputy commissioner, whether they are taking out any other. My lord.
You have not taken steps for dusty service of notice?
My lord. It's for last time, my lord, I have taken steps, my lord. 4 and 5.
When?
When the office has reported that no steps have been taken for serving respond number 6, dusty. The land council for the petitioner, however, submits that steps have been taken. If no steps have been taken up till now, comma, let fresh steps be taken for service of notice on respond number 6, dusty, returnable on your date after 3 weeks. In the meantime, the affidavit on behalf of respond number 5 may be filed.
1st of September. Item 2.
May it please your lordship.
Yes.
In this matter, we have filed a review application against the judgment of the division bench. Here today, the matter which is listed is review petition number 158 of the 2024.
That's
The main leading case is review petition 157 of 2024. In fact, I also prepared the whole case this morning and found that the 157, the leading case is not there. The council is 2 different councils of the other side.
all right. So
So
we
it-
fix it on another date.
Another
Put
date.
the review petition.
For the review, 157 along with this.
On last.
Let this review petition, let the review petition number 158 of 2024 be listed along with review petition number 157 of 2024
Lordship.
on your date, whatever date is suitable to you,
Today is Wednesday. Could it be on Friday also?
this Friday.
This Friday, if it
Yes.
is convenient to the honorable court, otherwise,
This Friday, this spot would not be available.
Lordship.
So the next Friday, if you want,
Yes,
the
Lordship.
next Friday.
Deeply obliged, Lordship.
22/8. Item 3.
Here, my lord, state has preferred and review application, my lord. State has preferred and review application, my lord.
You have preferred a
Yes,
review.
my lord. And on my lord,
What is?
1/8/2025, my lord. 1st of August, my lord was pleased to issue notice on the delay condonation petition, my lord.
All right. Let this petition be listed after the disposal of the review petition preferred against the impugned judgment,
Dated 12.
preferably on after 4 weeks.
Yes, sir.
Obliged.
8-9.
Give the number of the review petition also. Give the number of the review.
Not come, but it's not numbered. In delay condonation petition, notice was issued, my lord. I'll give.
Filing number, you give the filing number.
Yes.
Filing an IA. Item number 4.
May I please your lordship? There is a delay condonation of 147 days, lordship.
Who appears for respondents number 1 and 2?
Steps has been taken, lordship. Steps has been taken.
That's right. Awaiting the awaiting the report regarding service of notice on respondent number 1 and 2 and their appearance in the matter. Then this case is adjourned to after 2 weeks. 2 weeks, 3 weeks, depending upon the calendar. It shouldn't be more. Yes.
Much obliged, lordship.
29/8. Item number 5.
May I be slow?
Respondents number 9 to 14. You are appearing for whom?
Yes, my lord. I'm appearing for the 1 and 2, my lord.
1 and 2.
Yes.
Any appearance on behalf of respondents number 9 to 24? Any idea about the service of notice on response number 9 to 24?
No.
I'm asking you, gentlemen.
Lordship, this is content petition, item number 5.
It's item number 5, my lord.
This is item number 7, no?
5.
Item number 5. I'm so sorry.
Who has not entered appearance?
As per last order, court reminder was sent and today Lordship is appearing on behalf of
appearing.
respondent number 2.
1 and 2, my lord.
1 and 2 is
So you're appearing for response number 1?
Yes, my lord.
All right. Yes.
Lordship, in this case, Lordship, in the writ appeal, Lordship, the direction was that petitioner's provincialization order of 2014 was revived. But till date, Lordship, petitioner was not allowed to, Lordship, work in the school, although he's working without signing the attendance register.
What is it?
I have the instruction to file a review against this order, my lord. So may I pray for some time so that I can, at least 2 weeks time, my lord.
But that cannot be a ground for delaying this.
That I
No
understand, my lord.
contempt petition.
One sense so that I can.
Mr. N.J. Khataniar, learned advocate appearing for response number 1 and 2, submits that he has received instructions for filing review against the judgment which has not yet been complied with. Let that be done without wasting any time. Mr. Khataniar shall inform this court on the next date about the status of the review petition so filed by him. List this matter after 4 weeks.
Obliged.
5-9. Item 7.
Please, notes.
Please, your lordship.
Awaiting the service of notice on
Yes, your lordship.
on response.
I
number
appear for 2 to 8 minutes.
That's right, we are
9 to
9 to 24.
90-24.
Land Council, the response number 2 to 8 stand represented to a council. Awaiting the service of notice on response number 9 to 24 and their appearance in the matter. The case is adjourned to.
I have just one short submission to make. They have filed an additional affidavit in the writ appeal. Along with the additional affidavit, they have annexed certain documents which are not part of the writ petition minutes.
or the entire proceedings. Without an application for placing on record additional documents, those documents may not be taken. They may be asked to
That's
file a
right,
formal.
but on the next day, you make that objection.
All right.
But if the date
I'll-
may be
and
fixed.
my lord, if my lords can just grant me also an opportunity to file a reply response to
In the
the.
meantime, since you have appeared, you
Please.
don't need a,
All right.
you don't require the leave of the court to file any.
My lords,
affidavit.
unfortunately, during the writ proceedings, my learned friend refused to accept service of an affidavit saying you don't have leave of the court.
In writ appeals, no need for any affidavit. and
I'll file it. I'll
All
file.
the records are there.
I'll-
But even then, if you want something to be brought on record, you're at liberty. I mean.
Some new things have been said in the writ bill. I just want to respond to.
So if you deem it necessary, you file your affidavit. Nobody is stopping you.
I'll do. Can I have it on, sorry,
8th of September.
can it please be 10th of September?
Not, 10th of September, yeah, please.
Highly obliged.
Item number 8,
Has it come for orders?
May I please, Your Lord. My lord, this contempt petition is preferred for violation of judgment and order dated 26.
Violation or non-compliance?
Lord, in fact, violation also because the person who has been held to be ineligible.
Let's see the operative part of the judgment
Lordship will get
for
it
the
at
violation of which you have preferred this.
page
contempt
55.
case.
Prior to that, subject to Lordship permission, may I place the WPC judgment? Because,
That's what I'm asking.
yes, Lord, the judgment passed in the repetition
It should be part of this record.
8/5/2025, my lord. It is at page 43. Starts from page 43.
Now,
But-
let's see the single judge's order.
Single judge order, no? It starts from page 43. And operative portion at page 53, my lord. Paragraph 22, starts from paragraph 22.
Paragraph,
22, page 53.
Well, it's 54, consider.
read the paragraph.
Having considered that the respondent number 4 is not eligible to be promoted to the post of vice principal in the homeopathic medical college, and considering that there is a draft rule, that is the Assam Homeopathic Education Service Rule 2023, and the respondent number 4 is currently serving as a reader, I am of the considered view that the appointment of respondent number 4 as vice principal, even though as an in-charge for a temporary period, would not be sustainable. As even for temporary appointment, one must be eligible, and the petitioner by now has become eligible for the post. Thus, the appointment of respondent number 4 to the post of in-charge vice principal is not sustainable, and accordingly, the impugned notification dated 11/11/2024 issued by the commissioner and secretary to the government of Assam.
That's right. And how,
is set aside.
what modification has been carried out by the division bench?
My lord, but in this order, he was allowed.
Answer the question of the court first.
My lord, in writ appeal, which I challenged the last part of the judgment and order of the
Read para
petition.
19.
Lordship will get the page 60, the 11%, 60, starts from paragraph 16.
Okay.
In the case in hand, the issue is about holding the charge of vice principal of the homeopathic college in view of the peculiar situation emerging from the suspension of the principal in charge of the homeopathic college. In the meantime, on 5/5/2025, if the respondent number 4 is allowed to hold the charge of vice principal in charge till the completion of the selection process as directed by the learned single judge within a period of 4 months from such and such, the respondent number 4 would in essence be running the affairs of the homeopathic college as the head of the institution in the absence of a regular principal or in charge principal, whereas he is not even eligible to hold the post of vice principal even on in charge basis for a temporary period due to his ineligibility, allowing the
Like
respondent
what time limit was given by the single judge for completing the selection process?
4 months, my lord.
4 months. 4 months have passed.
No, my lord. But
Then
no, I am before your lordship that honorable division bench set aside that part whereby learned single judge allowed the respondent number 3 hearing to continue as vice principal till completion of the process. That has been set aside. But respondent number 1 and 2, that are complying this, my lord, and it was also directed by the honorable division bench that eligible person is to be entrusted with the charge of principal. That is not being done. On the other hand, one administrative officer is allowed to hold the charge. And that person is continuing as vice principal till that he is issuing the official communications. Well, that I have annexed that. Annexure 16, page 67 onwards. After passing of division bench judgment, he is holding the post of vice principal.
Yes, who appears for the other side?
No, notice is not issued yet.
Let notice be issued to which respondent?
So that's good.
No, not full. Who will be the answering respondent here?
1, 2, and 3, 1 and 2, commissioner and director. 3 is holding the post of vice principal even after setting aside his vice principal.
Let notice be issued to response number 1 and 2. To explain as to why the order passed by the division bench has not yet been complied with. The notice is accepted by any counsel for the state? Any counsel for state? Education department?
Health department.
Medical education.
Health.
Health department.
What's your name?
Health department. I'm.
No lawyer for the health department. Inform Mr. Gogoi, who represents the health department.
Yes.
We say that he accepts notice.
Yes.
The notice is accepted by. I mean, how do I say that unless I see the lawyer? Just inform him that he has to accept the notice. The notice is accepted by Mr. Gogoi, learned counsel, learned state counsel representing Medical Education and Research Department of the Government of Assam. The reply to the petition must be filed by the next date, 4 weeks.
5-9. Item number 9.
Me, please, your lordship.
The office has reported that response number 1, 2, 3, and 5 have not yet been served. So, awaiting the report regarding service of notice on response number 1 to 5. The matter is adjourned to after 2 weeks.
29-8. Item 10 and 11.
What is the urgency?
Lordship, the applicant in this case,
Yes.
he is without any income source and unable to sustain his family, your lordship.
And what
Yes.
is the judgment about?
Lordship, the judgment, the single judge had decided in our favor, your lordship, by stating that the
Reconsideration of penalty.
penalty, your lordship.
Even otherwise, let's dispose it off. Okay. What is his name? So-and-so, learned advocate presses IE number so-and-so for seeking an early hearing of early and expeditious hearing of the writ appeal on the grounds shown in the application. We are satisfied that this case requires an early hearing. Let the writ appeal be listed for early hearing. Let the writ appeal be listed for hearing after 3 weeks within first 5 cases. 3 weeks on the hearing day.
Both the writ appeals. State also has filed the writ appeal. Both the writ appeals will be heard.
Both the writ, all the writ. Connected matters come automatically.
Oh, yes.
2nd of September. Item number 12.
An application for
Let
condemnation.
notice be issued. There is an application seeking condemnation or delay of 341 days in preferring the appeal. Let notice be issued to the respondents on steps being taken by the appellant within a proposed appellant. The appellant within a period of 1 week, both modes returnable on up 4 weeks.
Well, may I be permitted to take dusty also, my lord?
The respondents shall also be served dusty on requisites to be filed by the appellant in the office. The office shall hand over copy of the notices to the learned counsel for the appellant to serve dusty on the respondents.
My lord.
The learned counsel for the appellant shall thereafter file a compliance report.
Yes, sir.
8th of September. Item 13 and 14.
May it please your lordship. My lord, we have filed this IA, my lord.
Yes.
We have challenged the, my lord, introduction of this inner line permit for this particular district of Dimapur. My lord. My lord, historically, for example, my lord, this petitioner,
Yes.
he belongs to this Dimasa tribe. They are the sons of the soil. Now they are supposed to take IPL. My lord. My lord, in respect of the first two category, a single judge of this honorable court has already passed an order, my lord. I may just give it. Copy to the.
Give us 1 minute.
Yes.
Lord,
1 second, 1 second, my lord. You appear for the
I'm for the state, my lord.
state of Nagaland.
Number 3 and 4 for the state of Nagaland.
I'm also appearing.
So I think it can wait till the hearing of the
That's right.
PIL.
My lord, yes.
I think it can wait till the hearing of the.
But
26
we
is
have
fixed.
filed this IA, my lord. I mean, I have to take a fixed course. Yeah. Not.
Mr. Balgopal, do you have anything to say?
No, in fact, since as your lordship has rightly mentioned, the matter is listed on 26th or 28th,
I think it's
28th.
listed on 26th of August.
Yes,
That's a fact, my lord. But my lord, learned single judge has already passed an order in respect of the.
That's right. So let it wait till 26th. Doesn't matter. Heavens would not fall. In a line permit for sons of soil. We'll see.
it
We'll
is a
see if it is
humorous,
not required, we will
No, my lord,
take the.
the original notification does not even envisage Dimapur.
All right.
It was
So
confined to my lord Naga Hills and Tuensang
let
district.
this IA be listed along with PIL number so and so on 28/6. 26/8.
26-8.
On 26/8/2025. The date slated for hearing of the PIL.
My lord, the
We'll
state has not
file
filed any counter.
In the meantime,
we are
in the
filing our
meantime,
They
the
do not
affidavit-
file also, lordship will take up because essentially a question of law. There's nothing like
That's
it.
right, that's right.
we'll
In the
file our
meantime,
affidavit.
in the meantime,
file
the state of Nagaland shall file the affidavit in response.
My lord,
Yes.
I was only wondering one thing, my lord. These are all protective discrimination. Once it is a protective discrimination, my lord, the ball is in their court now.
Mr. Chaudhary, I would not respond to it just now for the reason that we would have to go into the very
Yes,
question, the
yes.
very rationale of inner line permit, why it required, why the government would need it. So let's see the PIL and then.
So, my lord, when the question arises, why the government did, my lord, that is where the protective discrimination aspect comes in, my lord.
You're not suggesting that protective discrimination is unconstitutional, do you?
I think, my lord, in Jagadish Sharan's case,
No,
Supreme Court did visualize that situation.
Protective discrimination is something that is reverse discrimination.
Yes.
Protective discrimination. Let's see. Let's see. It has to muster the test of Article 14
Yes.
and the right to travel and all that.
This is a humorous petition, my lord. I call
it?
this petition a humorous petition. Humorous. I'll explain it on the next date.
All right, all right.
Obliged.
Item 15.
Delay. I mean, first time.
One.
Lord,
This application.
11 days.
You write like that. There's an application seeking condemnation of delay of service.
May I please,
Let,
Lordship, I have not received yet the notice. I am the respondent number 5.
notice has not been issued. We are issuing notice to you. You accept the notice here.
Yes, Lordship, but Lordship, I am the writ petitioner in the writ petition judgment dated. They have challenged the judgment dated 6/2025. I am the writ petitioner, Lordship. Due to some communication gap, I am unable to find the caveat. As my senior.
They are issuing notice
expired.
here only.
Notice should be issued.
Now your caveat or no caveat, you know about this case, no? There's an application seeking condonation of delay of 111 days in preferring the appeal, in preferring the writ appeal. So appellate notices be issued to the respondents on steps being taken by the appellant within a period of 2 weeks, both modes, returnable on so and so date.
10-9. Item 16.
With 17, no? No, 16. Coming for the first time? First time.
Say appeal preferred by the state, my lord. There's a delay of 81 days, my lord.
Same principle, no? Same principle. No extra benefit to the state. Notice to, you're appearing.
And on behalf of my petitioner, my lord.
Definitely. Respond. There's an application seeking condonation of delay of 81 days in preferring the appeal. Notice, next line, notice is accepted by Mr. So-and-so. Let the response affidavit be filed by the next date, 3 weeks.
Oblige,
It's 1-9. For admission, item 19.
Lord. Wait, please, Your Lordship. My lord, this is the case, the petition filed by the court officer of this registry of this honorable court, my lord.
Yes.
The rule 7-4 that has been issued amending
Give us
the
just give us 2 minutes.
I got it.
Yes, take us to the rules.
My-
Page,
Yes, I'm coming to the rules.
Page 68. Annex
page 68, yes.
Yes, ma'am. This space. This sub-rule 4 that has been amended by notification dated 24/7/2015, my lord. There is already a rule 7 sub-rule 4. So, my lord,
Read sub-rule 4.
here or in the book, my lord, there is already a,
Read sub-rule 4.
yes, my lord. The post of the court officer in the principal seat of the Guwahati High Court and the Kohima bench shall be filled up by calling options from the administrative officer judicial and the senior judicial assistant. The persons so appointed in the post of court officer shall maintain their respective seniority in their original cadres, that is in the cadre of AOJ or senior judicial assistant, and their further promotion will be considered on that basis. My lord, this later portion is ultra vires.
Why?
My lord, normally so far as the service jurisprudence is concerned, if a person is promoted to a substantive post following a due selection process, then his seniority cannot be retained in the feeder category. He has to maintain his seniority in the promoted category. So this aspect of the matter has been taken up by the Honorable Judges Committee of this Honorable Court in administrative side. The records have been annexed and it has been opined by that Honorable Judges Committee that this portion has to be struck down and it has to be.
Which is that committee which is opined?
My lord, it has been annexed, my lord. This petitioner, my lord.
So this was set aside. Then. Where is that? No. Is there any judgment in between?
Yes, it has been passed, my lord. That I was supposed to tell, my lord. I have given the number to my lord. I have not.
This is the judgment.
I think
He has given relief, my lord.
all aspects are dealt.
It has been
Giving
completed.
relief to me is not at all a question, only question here, my lord. I am an officer of the court and the employee of this registry has raised the question, my lord. And that has been taken care of in administrative side,
All right, we will hear it on some other day.
my lord.
After we go through this just.
My lord.
Let this matter come up for consideration on. Give after, any date after 16th of.
Obliged.
No, not 19th. Make it next.
After 19 next week.
First week of September, my lord. If not inconvenient, first week of September.
First week of September.
September.
Yes, yes.
Mine.
Obliged.
Obliged.
Item 21.
Yes,
May I please?
yes.
Okay, the present appeal has been preferred against the order and judgment dated 26/11/24 lordship annexure B page number.
Your lordship, I don't have a copy of the memo of appeals.
Can't hear you louder.
I don't have a copy of the appeal.
It's coming for the first time.
Yes,
Is it coming for the first time?
yes, yes. Earlier it was condoned. The delay was condoned. There was a delay.
Let a copy of the brief be handed over to
As the, for the respondent for.
Mr. S. Datta, learned counsel appearing for respondent number 4, who may put in his response to this appeal, if so deemed necessary by the next date. Re-notify on after 2 weeks.
Obliged.
Not.
28. Item 22.
My lord.
Yes.
In this case, my lord, by the previous order, lordship has required survey report, my lord.
What is it?
Survey report, my lord.
What survey?
About the, my lord, the identification of the property. My son has taken loan showing mortgaging his own land, but my house has been, my lord, taken symbolic possession, my lord. That is my grievance here.
No, your property was mortgaged by your son.
My lord, my property was not mortgaged.
Yes.
His own property was mortgaged.
Yes,
For loan.
yes.
As per the notice, symbolic possession notice also
Why has it-
indicates.
Yeah.
But my property having a house has been attached. My lord, the symbolic notice, possession notice has been attached on my house. My lord, kindly have a look at my annexure 1.
It, let's see, where have you stated so in your petition?
My lord.
Just give us a minute.
May I please, sir?
Yes, you appear for the bank.
Yes, Your Lordship.
What do you have to say?
Your Lordship, as per the preliminary inquiry, we have found that there was some mistake because both the buildings are in so close proximity.
That's right. So you withdraw that,
Yes, Your Lordship, we have already removed the possession notice from the conspicuous place of the property, and we are in a process to issue a letter, Your Lordship.
so we can dispose of this petition on his undertaking.
My lord.
Can I have your name, please? Mr.
M. Sharma, Your Lordship.
Thank you. This writ petition has been filed seeking intervention of this court against the unauthorized symbolic possession, against the respondent number 5 taking the symbolic possession of the house of the writ petitioner in question in an unauthorized manner. The records reveal that the son of the writ petitioner had taken loan after mortgaging his share of the property. It appears that the loan was not repaid. But before the loan account could be declared NPA, symbolic possession of the house of the appellant was taken. Mr. M. Sharma, learned counsel for respondent number 5, has at the outset very fairly submitted that such symbolic possession of the house of the petitioner was taken on some confusion because the house in question stands in close proximity to the land which had been mortgaged. Finding this error, the respondent number 5 has taken down the notice, has removed the affixation of symbolic possession of the house of the petitioner. He has further submitted that necessary corrective steps shall be taken shortly. Based on this undertaking, we dispose of this writ petition with a direction that the due process shall be followed by the respondent number 5 for securing the loan granted to the son of the petitioner, who has an independent identity and who holds land exclusively, which only had been mortgaged in the past. We order accordingly. The writ petition stands this.
Deeply obliged. Your Lordship, the account was declared NPA. Thereafter only we have taken the steps.
But there is a pleading that it was not declared NPA.
No, Your Lordship, possession notice cannot be taken before.
After the account was declared an NPA, possession notice was given. However, the house of the petitioner was taken symbolic possession of on account of such confusion which has been stated.
Item 23.
Who appears for the petitioner? It appears that nobody has been appearing in this matter on behalf of the petitioner. The petition is dismissed for non-prosecution. With the liberty to the petitioner to have the case revived, it should be dismissed for non-prosecution. The allegation is that the compensation amount, which should have gone to the landholders, that has been swindled, bungled away.
But those persons, my lord, they have approached the single judge, and single judge has already disposed of all the.
All right, therefore, he is not coming. Let's.
My lord. And the land also, my lord, land has also been already, my lord, allotted, my lord, in the name of the president, my lord. Acquisition has been completed, my lord, that particular.
All right.
Item 24.
Yes,
Pleasure, Lordship. This appeal is preferred by the state of Assam, Lordship,
yes.
whereby challenging the Lordship imping order dated Lordship 7/12/23, Lordship, whereby
1 minute, 1 minute.
Lordship.
Let's see let's see that part of the operative part of the judgment of the learned single judge.
My lord, may I kindly come to page 21, Lordship. It starts from paragraph 8, Lordship, where it's reflect the earlier review order. Then my lord, may I kindly come to 9, paragraph 9, page 22, Lordship.
Have you placed the order passed in WPC number 1463 of 2014?
Lordship,
The earlier round of litigation
Lordship,
by the respondent,
Lordship,
whereby the state of Assam was directed to
Lordship,
accord him the same status of provincialization
Lordship, Lordship.
as had been done by the others, as has been given to the
That
others.
has been not attained finality, Lordship.
That has not attained finality.
That part, that exercise, as per the honorable court's order, that some exercise was carried out, Lordship. In the meantime, the act was stuck
No,
down,
no, but when this act of 2017 was enacted,
Lordship,
in fact, it was made clear
Lordship.
that any legal right which had crystallized under the Act of 2011, with a direction of the court
Lordship,
for giving him the same benefit as other two employees,
Lordship, Lordship,
it was almost crystallized.
Lordship,
So therefore, can you take the plea that now it is under 2018 and therefore he would not get the benefit?
Lordship, the review, in respect to the review, Lordship, that those persons whose service were provincialized at the relevant point of time, they have the rights. It is the, otherwise, and
Lord, that is page 71, what my lord is,
Page 71.
yes, that order is my lord. It was a consent order. They only said I can be accommodated because by mistake I was left out.
that part no dispute. Otherwise, Lordship, 2015 onwards, Lordship, up to 2021, they are sitting idle, Lordship. Some lapses the government, even petitioner also not approach this honorable court before file any contempt petition also, Lordship.
Just give us one minute. You're not teaching. Huh? So, I don't think you have a case.
Otherwise, Lordship, I'm trying to satisfy Lordship. Yes, because in 2015, the Honorable Court's order was passed, Lordship. And we have acted upon 2021, Lordship. After that, they have come in. In up to 2015, order was passed on 19 to 2015.
Can that be a ground? Can that be a ground?
19 to, I satisfy, 19 to 2015, Lordship. They are ideally sitting, even contempt period is also about.
This plea you never took before the 11th single judge.
Lordship. Lordship.
Did you take that plea before the 11th?
Lordship, we have taken the plea.
No, it is not there in the judgment.
We have argued that particular plea, but that was not reflected in the order, Lordship. It is our
Where have
specific,
you stated in your memo of appeal?
Lordship,
Where have you stated that in your memo of appeal?
regarding that contempt part, Lordship. That part we have
Not
not,
the contempt part.
Lordship,
That you had taken the plea that after so many years,
Lordship,
the respondent, that's the writ petitioner,
Lordship.
he sat on his own rights,
Lordship.
did not ask for
There
provincialization.
is no
And
specific,
by that time, it was all set aside and therefore no retrospectivity could have been
Lordship,
given.
that specific,
Have you
that-
taken that plea?
that specific plea is not there. Otherwise, Lordship, our case,
That was before that. So the judgment was passed, it was not implemented.
Whose services provided prior to 2019 shall continue their services.
2018. Taken.
otherwise, just Lordship. In review order, my lord, may kindly peruse for a moment review order, Lordship. Review just one paragraph, I read out, Lordship. Paragraph,
Review.
Paragraph 18, Lordship. It is not there. It will be shown.
Where is that? Page,
Bimal couldn't do this. Bimal couldn't.
page,
Lordship just the hand of Lordship. Bimal couldn't do it. And list of books I have given. Bimal couldn't do it.
But after reviewing new act is come.
Lordship.
Review of the judgment. Writing down to-
review that judgment.
That judgment. That judgment, I just read out paragraph 18, Lordship. What the paragraph 18 says, Lordship.
Paragraph 18.
Paragraph 18, Lordship.
Paragraph 19 of that review is quoted.
Paragraph 18, Lordship. The state in their application have stated that the group they have concern with are those who have retired and are drawing pension. Another category who are, Lordship, got it? Now, government employee and are receive regular scale of pay, and the people of same class who have moved in their careers in this life. There are around so and so employees for whom vested rights are already created under 2011 enactment. But though retrospective application of our 23rd September 2016 judgment, they may not only lose their job, but also disentitled to pension and salary. Moreover, the questions of recovery of the already disbursed salary and pensions may embargo. The harsh impact of the retrospective application will crippling for the already provincialized group of their livelihood and in turn life itself will be adversely impacted. All such debilitating consequences will occur when any opportunity of hearing to this category.
That is with respect to other aspects.
Other aspect as because Lordship here in this case,
Read paragraph 19.
in view of the circumstance, we are of the considered view that the rights of the employee who have been benefited under the stuck down statute can be taken care by the giving retrospectively. That part is there. Otherwise, Lordship,
And
here petitioner not benefited, Lordship.
in the, what is this benefit?
Lordship. His
Benefit has to
provincialization,
be,
his
benefit has
provincialization
to
was
be-
not done, Lordship.
there has to be an overall benefit. No?
His provincialization was not done, Lordship. Even Lordship, he is not come to the court, then the provincialization is not done, Lordship. And under 2015 order, Lordship, his provincialization was not done, Lordship. In the meantime,
We
court,
have heard you.
Lordship,
Anything else that you want to say?
Lordship.
Anything else that you want to say?
Yeah, Lordship, I want to rely to judgment of the Honorable Apex Court, where already settled proposition of law, Lordship. That Surya Kumar case and RR Kisu's case, Lordship.
Yes.
Here, Lordship, that particular order is today, as on that is an unexecutable order, Lordship. We cannot go in 2015, Lordship.
Take that. The state of Assam is in appeal against the impugned judgment dated so and so, passed in WPC number so and so. The respondent number 1, who had been appointed as a grade 4 employee in Rajiv Gandhi Memorial College, was not given the benefit of provincialization under the Assam Venture Educational Institution Provincialization of Services Act 2011 for clerical reasons, despite other persons of the same ilk having been granted that benefit. The respondent thereafter chose to challenge the provincialization of the other employees, similarly situated, by WPC number 1463 of 2014. The learned single judge in that instance, finding the exercise to have been completed, did not disturb the same, but directed that the provincialization of the respondent number 1 shall be effected from the date when the services of the other two employees were provincialized. It appears from the records that this mandamus was not followed. First up, later, the Act of 2011 referred to above was struck down as invalid. And Assam Education Provincialization of Services of Non-Teaching Staff of the Venture Educational Institutions Act 2018 came to be promulgated, providing provincialization to the non-teaching staff on fixed salary of 8,700 per month. On fixed salary. The respondent number one, therefore, the services of respondent number one, therefore, was provincialized under the Act of 2018 on a fixed salary of rupees 8,700 per month with effect from 1/1/2021. The respondent number one chose to challenge the aforementioned decision on the ground that his provincialization should have been effected under the Act of 2011 and not under the Act of 2018, especially when a mandamus had been issued by this court, which was never assailed by the state of Assam in any proceeding whatsoever. In any proceeding whatsoever. After the provincialization of the respondent number one under the 2018 Act on a fixed salary, he challenged that decision before this court, before the High Court again, by WPC number 6144 of 2021. The learned single judge, while dealing with the matter, took note of the argument on behalf of the state that in state of Manipur and others versus Suraj Kumar Okram and others, 2022 SCC online, SC 130, it has been held that where a statute is adjudged unconstitutional, it is as if it had never been. Rights cannot be built up under such statute, and contracts which depend upon it for their consideration are void. It constitutes a protection to no one who has acted under it, and no one can be punished for having refused obedience to it before the decision was made. Repelling such an argument on behalf of the state, the learned single judge found that in the review of the judgment by which the Act of 2011 had been struck down as invalid, it was clearly observed in the review petition number 167 of 2016. It was clearly observed that the rights of the employees who have been benefited under the struck down statute could be taken care of by giving retrospective effect to the proposed legislation, if the legislature so decides. It was further clarified that till it was done, the services of the provincialized category and their status as government employees ought not to be disturbed who would continue to receive all the benefits which they would have been getting under the Provincialization Act of 2011, since struck down by the judgment under review. Even the Act of 2018 has a savings clause which provides that notwithstanding the repeal of the Act of 2011, all the non-teaching staff of the venture educational institutions whose services were provincialized prior to 23/9/2016 would continue, and their services and cases shall be reviewed as per the eligibility norms set forth for provincialization under the Act of 2018. On this ground alone, the writ petition preferred by respondent number 1 was allowed, and the Director of Higher Education, Assam, was directed to do the needful for provincialization of respondent number 1 under the Act of 2011 in compliance of the order dated 19/2/2015 passed in WPC number 1463 of 2014, referred to above. The necessary follow-up action had to be taken within a period of 3 months from the date of the judgment. While assailing the judgment, the Learned Counsel for the state submitted that notwithstanding the judgment of the learned single judge in writ petition or Palaji writ petition, like that, writ petition number so and so, no order had been passed for provincializing the services of respondent number 1. First off, in that case, the savings clause would not get attracted so far as we are noting your savings clause would not get attracted to the case of the respondent number 1. The second limb of his argument is that the respondent number 1 never questioned the inaction of the state in not provincializing the services, not provincializing his service, notwithstanding the specific mandamus issued by the writ court. He has further submitted that since the respondent number 1 had not been proactive, rather had slept over his rights, he ought not to be deemed to have been benefited under the 2011 Act, since struck down for any benefit in the service. The aforementioned grounds do not appeal to us for the reason.
Another ground is the ground number Z. My lord, may kindly postpone.
Ground number?
Z lawsuit. Page 13 lawsuit. You start from page 12 lawsuit. Last 2 lines is start from.
Page number?
Page number 12 is start from lawsuit. Lawsuit.
And lastly, it was submitted on behalf, and lastly, it was submitted by the Learned Counsel for the state that while according the benefit to the respondent number 1, the learned single judge erred in law by failing to appreciate the settled proposition of law that the doctrine of prospective overruling can be applied by the Honorable Supreme Court only to save past transactions under earlier decisions, which stand superseded by the statute which has been held to be unconstitutional. None of these grounds appeal to us for the reason that the rights of respondent number one had already been crystallized, but for the formal issuance of an order by the government. True it is that the respondent number one was not cognizant of his rights and never approached the court for implementation. Never approached the court for willful contempt of the order passed by the court by the respondents, but that would not take away the crystallized right in favor of respondent number one. We therefore are in agreement with the reasoning given by the learned single judge in allowing the petition of respondent number one and directing for his being provincialized, his services being provincialized under the 2011 Act in view of the savings clause in the 2018 Act, as also the judgment of this court in WPC number so-and-so, which was never assailed by the state. For the aforementioned reason, we dismiss this appeal, but without, dismiss this appeal and make it cost easy.
Deputy of Law.
We have heard so-and-so. Mr. Counsel, you have to give your slip, no? We have heard Sri K. Gogoi, learned advocate for the appellant state, and Mr.
J. Abidin.
J. Abidin for respondent number one. Other respondents also. Take the slip, huh? Chalo,
Deputy
yes.
of Law.
Item 25.
Yes.
Instructions have come in. If I may please be granted a few days' time to file the counter affidavit.
May I submit with lordship? Permission, lordship. Last evening also, I have visited the entire locality, which is just nearby.
They have not done anything.
Not done anything. Even the coastal road means towards RBI, towards Don Bosco.
They are not
School.
asking for something big. They're only asking for repair of the sidewalks, tactile paving, which otherwise you are supposed to do. No parking zones there, and so on and so forth. These
Zebra
are-
crossing
These
also
are
not.
specially abled persons. You must take care of them. And they're not demanding much. Is the government? MS Sharma, learned counsel for the state, submits that the instructions have been received by her, on the basis of which she would be putting in a response by the next date. It appears that this PIL, next paragraph, it appears that this PIL has been filed by a person with locomotor disability who has only sought court's attention and perhaps intervention against state inaction in not taking care of specially abled persons from continuing with their studies in and around the university campus, especially Lakshmanath Besbarwa Road and Hostel Road. The conditions of the sidewalks of the road have become hazardous for physically, for the specially abled persons. The demand of the petitioner is that the sidewalks and roads within and around the university be repaired. Semicolon. Tactile paving should be provided for visually impaired persons. The area should be made free of parking. And effort should be made to remove the unauthorized street vendors by making the area a no vending zone. It has also been suggested that all physical obstructions on the road and sideway, like bamboo poles and unauthorized structures, ought to be removed from the pathways. The land counsel for the petitioner has informed this court that she had personally visited that road yesterday, but had not found anything done on behalf of the state to remove the difficulties for such able, or such differently abled person. MS Sharma shall also indicate in the affidavit which she would file about the steps taken and the possible time and the expected time within which such changes could be made about, thereby redressing the grievance of the petitioner and other similarly situated, especially abled persons. Right, denotify of. Give a date after 2 weeks. And do something, start something, so that you are not confronted with this situation that nothing has been done. At least remove the poles, make it obstruction free. You're bound to do that. All right, yes.
19.
Deeply closed.
Item 27.
May I please?
Yes.
But this, pursuant to the order of this honorable court, we have already filed the affidavit.
You have filed the
All- Yes, all the district. In us.
This
Have you
issue
seen
is
the
basic, yes, Milord. I have received, the issue is basically, Milord, providing the basic amenities in the religious places in the state. All the districts were, Milord, directed to file affidavit. And they filed the affidavit. Most of the districts, deputy commissioners' response in their affidavit is that no record available. Some of them,
No
they have,
record of what? No record of the shrines.
no, shrines is there, but other details like toilets, Milord, water facility.
That's not what we want, no? That's not what we want.
Order dated 25/1/23 is clear, but
So what I'll do, Milord, subject to Milord, your lordship's permission, Milord, what I'll do, Milord, I'll prepare a report.
And do comparative chart.
Yes,
wherever
Milord,
it is
compiling details given by all the deputy commissioners, Milord, in one consolidated thing so that your lordships can have a look and get a picture of the state of affairs. But in most of the districts, your lordships, the reply that has come is that no records available under the headings, Milord. Like toilets, water facility, drinking water facility. Entire exercise has become, Milord, since 1.5 years we have waited for this affidavit.
Taken. The Honorable Supreme Court in WPC number 649 of 2018. The WPC. In WPC number 649 of 2018. 649 of 2018. Had observed the need for taking care of the shrines, especially their upkeep. This PIL was taken suo moto. The direction was issued for all the district commissioners / district magistrates of the districts to file reports regarding the number of shrines in such district and the facilities which should we provided the to the persons visiting such shrines. Now, it appears that pursuant to several orders passed by this court, the reports from all the districts have been filed. But as pointed out by Mr. by Mr. Das, learned advocate, no definite information as would be required in this case have been furnished. He submits that he shall go through the reports and shall make a comparative study with his suggestions on which directions could be issued to the respective district commissioners for the need for. He seeks a short accommodation. He therefore seeks a short accommodation. Let this matter be listed again for further consideration on after 4 weeks. Fine.
Deeply applied.
Deeply. 8-9.
We'll get up for 5 minutes. We'll come back after 5 minutes. Yes. You have called 31.
Item 31 and 32.
May I please also, madam. In this petition, my lord. This challenge before the lordship, my lord. My lord, the application of the, my lord, Assam Land Record Service in BTC area, my lord. So BTC is a 6 rule area, my lord. The rule is, my lord, framed by the state of Assam, my lord.
1 minute. Yes,
My lord, the Bodoland Territorial Council, my lord, is a six-citizen area, my lord, under the constitution of
we
India, my
understand
lord.
you.
So, my lord,
Issue.
my lord, issue is that, my lord, the petitioner before lordship, my lord, they have completed a 6-month RCC training course, my lord.
That's right. You are already in employment.
No, my lord. No,
You're not in
no,
employment.
no, no. The RCC training course is for the qualification to apply for the Lat Mandal post, my lord, for the post of Lat Mandal, my lord. That rule was earlier, it was, my lord,
No, no, only when you get appointed.
I'm not challenging my appointment, my lord.
No. So these persons cannot. There's no transaction. What is to be done now?
Now, my lord,
They are within their competence to enact this rule where higher secondary is no longer the minimum qualification.
that is one part.
Graduation is the qualification.
My lord, the 50%
So
which,
all that you can say is that your 6 months training
my lord,
of recording,
my lord.
I mean, that would become futile.
It-
And there is no transitional provision.
My-
That you're right.
My lord,
Something should have been done.
my lord.
And you should have been given some time to upgrade your educational standard with, you
My-
know, relaxation of age.
My lord,
I think that is always the position when a new rule is brought about.
my lord.
But then there would be many who would be actually graduates and graduation is the basic degree today.
With 50% marks in my lord statistics, maths and my lord geography, that's very hard to get,
That cannot,
very hard to get.
that is their prerogative. We
The
can't.
college also not available
With
providing
respect
those
to
subjects.
What should be done?
Right.
If there is any transitional problem. Yes, Mr. Who appears for Bodoland?
Bodoland, my lord, I thought, my lord, council for the PTC, my lord.
Yeah. But then advertisement has been issued by. Who are they? Who are you? Who has issued the advertisement?
My lord, by the BTC authority, my lord.
Huh?
BTC, Bodoland Territorial Council, my lord, and except for my lord. That also, my lord, neither they are issued the any new rule nor in the, my lord, old rules, my lord. It seems to be, my lord,
Let's see the advertisement first.
my lord,
Page,
90, my lord,
page 19.
90, 90. The advertisement itself, my lord.
No,
Advertisement is not 90 days old.
no, this is the same visit expert. From page 90.
90. My lord, lordship, I have the second case, my lord. The WBC 690, my lord, not the first, my lord.
7408 is 90.
My lord, no, my lord, 693. There are two repetition, my lord, the second repetition, my lord.
Formula to be-
See, Mr. Council, we cannot do anything about it except for asking the BTC lawyer, BTC administration, whether they have formally accepted this, they have adopted this Assam
My lord.
rules.
To my knowledge, they have not adopted, my lord, that.
You are appearing for BTC.
BTC lordship,
Yes,
in
what
my
you have to say to
affidavit
this?
lordship.
That you have, that you have-
106 paragraph 5.
that you have issued this advertisement, if you are at, if you have item number 31 with you,
Yes, 31.
7408 of 2020, correct? Is that the brief that you are holding?
It's WBC 7408/2023, 31 lordship.
7408. Now, page 94. A very short question that you will be required to answer. This is the advertisement.
Yes.
For record keepers. What is this post?
This is not-
Land record assistant. This is the advertisement.
Yes, lordship.
So this is not the advertisement for the purposes of appointment straight away.
Yes, this is
But
not
for
for
6
appointment.
months training.
It's for trading only.
That's right.
Yes,
So this is the precursor to any appointment.
yes.
Is anybody who is qualified, who has had training of 6 months, would be appointed as land records assistant.
And the qualification fixes.
Qualification
Graduate,
fixes this.
graduate.
Agree.
And so far as the.
No difficulty.
No,
But
yes.
then this, you have issued this advertisement on the basis of the rules of 2023
Yes,
framed by the Assam government,
Yeah.
which you have not formally adopted. Have you?
that is his submission, lordship. So far as my affidavit is concerned, lord.
You have filed your affidavit?
Yes, lord.
Yes.
It's already.
Let's see your affidavit.
If lordship comes to page 106, lordship,
106.
it's paragraph 5, lordship.
1 second. No, where does it begin from?
It starts from,
104, yes.
if lordship comes to page 106, paragraph 5, lordship.
This is by respondent number 4. Who is respondent number 4 here?
Respondent number 4, this is by the, this is by respondent number 2, lordship.
No,
One Dhira South.
No, this is.
so we are concerned with.
This is by the
quality
state.
administration.
No, 7408/2020.
The affidavit should be on behalf of respondent number 1 and 2, that's all.
It is by respondent number 2.
It's by respondent number 2.
Yes.
It says respondent number 4. Come
Page
to
will
page
be-
104.
No, this is by one Dhira South, lordship. It is the-
No, we are here.
Lordship, my affidavit is,
Give us the page number.
page number 106.
Of which brief? There are 2 briefs here.
This is 7408.
So you should say that, no?
This is serial number 31, Lord.
Yes. 7408.
7408, yes.
No. No, I don't think so.
Page 120.
By respondent, we have the affidavits of respondents number 3 and 4.
Lord, there will be some,
My lord, earlier that state has filed affidavit. There is a, my pagination is not. the part.
Respondent number 2, the last of the affidavits, yes.
It's a 120, I think it would be.
120.
Page 120.
paragraph 5, Lord.
Just,
I'm sorry.
No, it is.
Paragraph 5, Lord.
no. Affidavit in opposition filed by respondent number 2.
20.
It starts from page 120.
Yes. Just give us a minute.
April 121, 222.
122. Eight line, Lord. Accordingly, it was decided.
Where have you said that
Hello?
you have formally adopted the rules of 2000?
That formal adoption has not been mentioned, but it is, the line is, Lordship, accordingly, it was decided.
No,
Let me, in that case, Lord, let me go through, let me read the paragraph 5 itself, Lordship. That as regards to
We
the.
are at paragraph, we are at paragraph 5.
Yeah.
Yes,
Paragraph 5.
The Executive Council of Bodoland Territorial Council in its meeting held on 24/4/2023 decided to upgrade.
The
Now,
education and
this you
qualification.
can't do, no, you have to frame rules. And only then you can upgrade it. Notwithstanding the sixth schedule status.
Yes,
to
in this
BCC.
case, it is the.
Now, where is that Executive Council decision on 24?
It is that has not been enacted, but this is dated 24/4/2020.
Now, they have two questions. Number one, that this is in pursuance to a rule of 2023 framed by the government of Assam,
Lordship.
whereby the land record assistant, lot mandals are renamed as land record assistants. And the qualification would be graduation
Lordship.
with certain percentage of marks in particular subjects. Some relaxation for SC, ST and other OBC or whichever category. Now, you need to formally adopt that rule. And that rule could be questioned on the ground that there is no transitional provision. Suppose somebody who has already undergone a training of 6 months with a higher secondary degree, which was earlier the requirement, then you have to make some provision for it also, no? So that they get time to upgrade their academic qualification. And then you ask them to undergo further training if at all it is required. So when you make any rule, when you adopt any rule, you make some provision, transitional provisions also. That's the way you go about.
Lordship.
What do you have to say to this?
Lordship, so far as the petitioner specifics are concerned, Lordship, if Lordship comes to paragraph 7.
Now we are asking was general question, forget
Lordship-
about the petitioner.
Lordship, one public notice is there, Lordship. It was issued by the.
By Executive Council, you would change the qualification.
Lordship, in fact, Lordship, this is a part of the second writ petition, Lordship, this notification. If Lordship comes to the last paragraph.
It's very, you've taken the photocopy.
My lord, may I the type of my lord, it is not eligible to be with.
But you're required to notify the same through public notice. Have you notified it?
This particular notice, Lordship. No. The decision of 24/4/2023.
Try and understand what we are telling you. Have you notified it?
That instruction I have.
That is this advertisement you have issued pursuant to the rules.
Yeah.
Rules, you can till the time you frame your own rules, because these will fall under the transferred subjects.
Yes,
40 subjects for which you can make legislation,
Lordship.
correct?
Lordship.
So till the time, the transitional provision, you have made use of it, that you would notify that this particular rule of the Assam government is applicable here in BTC. Do you don't
No,
take
so far as
decision.
the earlier rule is concerned, that has already been notified, but so far as.
This advertisement is not under the earlier rules, no?
It is.
Because there it was, if you would have issued advertisement under the earlier rule, perhaps you would not have come here.
Lordship, if I have correctly understood, Lordship probably is talking about this decision of 24/4/2023 notification. So far as the earlier rule is concerned, that is already
Earlier rule is not in question.
Lordship. That
The
sub,
rule here also he is not questioning. Otherwise, it would have, I mean, that would be a different thing altogether. He cannot question it because this can be questioned. This rule is made by the Assam government.
Lordship.
There is no applicant for the post or for the training. Against this advertisement has not been issued by the Assam government against those rules.
By the petition.
This is by BTC. Therefore, we first want to be satisfied that you have formally notified the rules. Number one, then only you can issue an advertisement. And once you have issued you have notified, then we can also question you that what have you done for people who have already undergone 6 months training?
So far as second question is concerned, Lordship, that answer is at page 122, 123. This is the second part of paragraph 7. Same read.
Recruited qualification is the problem.
As recently, who have the requisite education as recent, who do not have. I think there is some mistake somewhere. Are you
No,
putting yourself properly?
So far as the appointment, eligibility of the appointments for recruitment, Lordship, that issue is yet to be decided. That is what they are trying to say. Lordship.
It is stated that no decision has yet been taken to debar the matter. All right, yes.
Successfully obtaining training.
So that decision is yet to be taken, yet to take, Lordship. And so far as the earlier,
Then you need not worry, no. This is an advertisement not for appointment, but for the
For
purposes
training.
of obtaining training,
yes,
right? For purposes of obtaining training, and they say that you are already trained with your original higher secondary certificate. Now, if they issue any notification for appointment and shut you out, and they say that only persons with higher degree under the new rules and under the new training, they will only be appointed, then perhaps you have a cause of action, otherwise not.
My lord, it is though it is not, my lord, in assertive ways, my lord, stated in the affidavit, my lord, but there is no such decision, my lord, in the council.
That's what he says. There is
And
no such decision.
Secondly, my lord, the rule they have not adopted, my lord, till now.
Forget about the rules now.
And secondly, my lord, advertisement, seems to be advertised for the post. Actually, it is to be only for the training,
You'll have to.
not against the post.
Just a minute. You'll have to file another affidavit. वो गलत लिखा है. That's obviously a typing error.
Then no meaning.
Take that. The petitioners, where is that advertisement page? And then
Page 94.
the petitioners have challenged the advertisement issued by the Office of the Director, Land Records and Surveys, BTC, Kokrajhar, dated 31st of May 2023, seeking applications from intending candidates to undergo 6 months recorders class course training bracket RCCT at Assam Survey and Settlement Training Center, Rajanagar, Dakhin Gaon, Guwahati, for the session 2023-24. Stop. In the aforementioned advertisement, the eligibility criteria has been fixed as the eligibility criteria with respect to educational qualification is that the intending applicant should be graduate in any discipline from a recognized university or institute with a minimum of 45% marks for SC, ST and 50% marks for general candidates in graduation. And such candidates having proficiency in the use of computer and information technology and having minimum 20 words per minute computer typing speed in Bodo/English/Assamese/Bengali could apply. it appears that in the past, for the post of Lot Mandal, which has now been renamed as Land Record Assistant, comma, RCCT training at the training center was required, which could have been obtained by any person having a higher secondary qualification. But however, later, with the promulgation of Assam Land Records Subordinate Service Rules 2023, comma, the basic qualification for obtaining such training, which is a precursor to the appointment / recruitment on such post, has been upgraded to graduation degree. The writ petitioners under the earlier existing rules had undertaken their training at the Assam Survey and Settlement Training Center under the rules of 1992, which were then in force. These they had higher secondary school leaving certificates with them. The concern of the petitioners is that without formally notifying the Assam Land Record Subordinate Service Rules of 2023, comma, the Office of the Director of Land Records and Surveys, comma, BTC, has come up with the advertisement, perhaps under the new rules of the Government of Assam, new rules of 2023 of the Government of Assam, seeking application from intending candidates to undergo 6 months RCCT training in the Survey and Settlement Training Center. This, comma, the petitioners argue, presupposes that any recruitment to such post of land record assistant would then stand limited to the new trainees under the trainees under the new rules. The contention on behalf of the appellant, contention on behalf of the petitioner is that some transitional provision ought to have been made after notifying and adopting the rules of 2023 of Assam, of the state of Assam, to be promulgated in Bodoland Territorial Council for such of the trained persons when they were only required to have a higher secondary education, higher secondary degree for undergoing such training. The Learned Council for the BTC, however, has submitted that the advertisement is in question is only with respect to 6 months training at the Assam Training Center for the purposes of appointment on the post of land record assistant. till date, the Land Council for the BTC has argued, no decision has been taken to debar such candidates who have successfully obtained proficiency certificates of RCCC training under the earlier rules of 1990. RCs. The aforementioned statement does not appear to be correct for the reason that a bare look at the advertisement clearly stipulates that candidates will be selected district-wise against the existing/probable vacancy of the post of lot mandals/recorders, which are likely to be vacant up to 31st of January 2026. No, I said, that be.
2026.
However, as an, it does not appear to be correct, of course, strike it off. Now, however, look at the advertisement at annexure 4 to the writ petition. It appears that the training under the new rules would enable candidates to appear against the existing/probable vacancy of the posts of lot mandal/recorders likely to fall vacant up to 31st of January 2026. This does not in any way preclude the possibility of the petitioners from being considered for such posts. However, a detailed affidavit in that regard would be required for us to close this petition now. The affidavit should also include whether the rules of 2023 have been notified by the BTC. The additional affidavit required by us must be filed by the next date, 2 weeks. Wait.
May I mention that apart, my lord, the 2023 is a service rule, my lord. This is 2020, but there is
It's
also
only
training rule,
for-
my lord.
That's all right. That's
So
all
if
right.
it is, my lord, service rule, the training is, my lord, after followed by, my lord, appointment, my lord,
Next.
not prior to that, my lord.
27 it.
I leverage, my lord.
Item 33.
Yes.
But your lordship, so the petitioner is the retired employee of Border Red Organization. He was in a special post, General Reserve Engineering Corps. Now, initially he was appointed as a pioneer. Thereafter, he was appointed as a painter and subsequent appointment.
1 minute, sir, 1 minute. Let me go through this judgment of the single judge. We'll get back to it.
All right.
Just take your seat. We'll call upon you.
Page 16.
All right. Yes. Yes, Mr. Daskar.
Milord, actually, petitioner was appointed as a pioneer. Thereafter, he was appointed as a painter, and his subsequent appointment was the post of leading hand. So, Milord, when he was holding the post of painter, and his scale of pay was equated with the mate, same scale.
Tell me one thing, what is the educational qualification required for you to be appointed as a pioneer or a painter? The original entry point,
Matriculation.
that's right.
Hmm.
And overseers are diploma holders
Yes,
and non-diploma holders also who get in situ promotion,
yes, yes.
correct? So diploma holders, whether overseers having diploma or non-diploma who are the promotees,
Huh.
they discharge the same function. There is no difficulty.
Right. And then they are having the same scale of pay.
Therefore, they are in the same.
They are having the same scale of pay,
Though the,
though the qualification is defined.
though the pay commission had made a distinction, but that was not found to be correct by the court.
Hmm.
But what is your comparison? On what basis would you say that you discharge the same work as that of an overseer?
No, so far
Costs are different. Somebody rises to the rank of mason. Other would rise to the rank of, I don't know what.
so far my post and the overseer posts are same rank.
No, how do you say that?
No, there's a rank, there is an admitted position. Rank is
Who
same.
admits it? Nobody admits it. Why do you say admitted position? Who admits this?
No, this is the learned single judge was of the view to count. Delhi High Court was the view, yeah, though you are of the same rank, but your duty is defined. So you are not in a position to accept your contention. That was the Delhi High Court judgment. And so far our High Court judgment is concerned, yes, in addition to that, so far your initial recruitment qualification, recruiting was a matriculation, and whereas the overseer's qualification is the diploma holder. That was the basic difference. But one thing that had not been taken into account, that even the promotees who were holding the qualification of the matriculation, then they are also entitled to have the scale of pay of overseer on being promotion.
That's right.
And
So
here
if
also we are.
In your line of promotion, there is no post of overseer.
No post, but on the lead handman.
Lead handman.
Lead handman,
How do
subsequent.
you say that lead handman and overseer discharge same kinds of functions?
Yes, that can be inferred because the subsequent promotional post of the lead handman is superintendent. And subsequent promotional post of the overseer is also superintendent.
So both are feeder of superintendent.
Both are the
Similar.
feeder post same. And even so the feeder post of overseer is mat, and feeder post of lead handman is also painter. While they are holding the post of mat as well as the painter, they are having the same scale of pay. Only difference below we are probably what the court wants to say. Only difference is that we are discharging all the technical duties, whereas the overseers are doing the technical duties. That is only.
Your duty is
Man management.
the security of the unit area, discipline of troops, licensing.
Man management.
Overseers,
They are also civil engineer, management of the civil engineering. This is the only difference. But the rank is same because the promotional post is same. From overseer to superintendent and from leading handman to superintendent. Feeder post is from mat to overseer and from painter to leading handman. This is my only contention.
I don't think you have a case. We can't allow this. Taken. Heard Mr. Dasgupta, learned senior advocate. Heard Mr. A. Dasgupta, learned advocate for the appellant, and Mr. S.V. Chaudhary for the respondent. The challenge in this field is to the judgment and order dated so and so, passed by a learned single judge in WPC number so and so. The appellant seeks parity of pay with the overseers. to state the case of the appellant in short. He is an employee of the Border Road Organization, specifically serving in the General Reserve Engineering Force. He was initially appointed as a pioneer and was promoted to the post of painter, and ultimately to the position of leading hand (non-technical), which in present day parlance is known as leading hand (administration). The claim of the appellant is that the position of a leading hand (admin) is equivalent to that of an overseer, sharing the same rank and responsibilities. Under such circumstances, the claim was that he and other persons in his category must be accorded the same pay scale of rupees 5,000 to 8,000, which is given to an overseer. The learned single judge examined the claim of the appellant and found that leading hand (administration) do not possess any diploma in engineering. Diploma in engineering. So far as the duties are concerned, overseers are engaged for performing the duties of mustering of casual paid laborers and supervising the civil engineering works related to construction of roads, bridges, and buildings. Semicolon, whereas the duties attached to the post of leading hand (admin) relates to security of unit area, discipline of troops, liaison duties, and other duties related with the general administration and man management. The nature of duties as attached to the post of leading hand and to that of the post of overseer are thus very different in nature, very different, with different responsibilities, inviting no comparison. It appears from the record that as per the 6th Pay Commission recommendation, the pay scale of rupees 5,000 to 8,000 per month is to be given to the posts wherein one of the eligibility criteria, prescribed for recruitment, is the possession of the candidate concerned of a diploma in particular trade. For recruitment to the post of leading hand admin, the basic qualification is not diploma, and therefore on a general reading of the recommendation, comma, such pay scale would not be applicable to the leading hand admit. Initially, non-diploma holders who were promoted to the rank of overseers were not accorded the same pay as was available to overseers with diploma. But later, with the intervention of the courts, comma, overseers, whether with or without diploma degree, whether with or without diploma qualification, came to be paid the same salary under the scale of 5,000 to 8,000. The petitioner, the appellant, admitted he does not possess diploma in engineering. His claim is based on a parity which is accorded no, his claim is based on the similar nature of work to that of an overseer. To that of overseer. As already noted above, the educational qualification prescribed for direct recruitment to the post of leading hand, bracket non-technical, in the recruitment rules of 1982 is only matriculation or equivalent with 3 years experience in construction work / supervision of labor / men. A comparison of the qualifications prescribed for direct recruitment to the cadre of leading hand, non-technical, and overseer would clearly reveal that it is different and the responsibilities too are different. On this ground, the prayer of the appellant / writ petitioner was rejected. We are in agreement with the conclusions arrived at by the learned single judge. That a leading hand, bracket admin, not being a part of the technical cadre of BRO, would not be entitled to be extended the same scale of pay as is extended to the overseers. The appeal, therefore, is dismissed. Ratifying the judgment delivered by the learned single judge.
Hearing.
Welcome.
Item 35.
Yes,
Your Honor, I have just received the affidavit as of now, and I will be requiring to file the
Rejoinder.
response in a two weeks time. I've just received it.
Sorry, Your Lordship.
all right. This is item number 35, no?
Yes, Your Lord. Yes, Your Lordship.
Right. Mr. I.S. Mazumdar.
Yeah.
Learned advocate for the petitioner. Submits that he has received the affidavit in opposition only recently. He would like to go through the same and respond if necessary. For the aforesaid purpose, he seeks a short adjournment, re-notify. It goes only in September. Our docket is full now.
Yeah.
May I please, Your Lordship? It is additional affidavit. Affidavit in opposition has already been given. It is additional affidavit.
The additional affidavit.
Yes,
in
In
the
terms of
updates
23-5 order.
Ye-
In
yes,
terms of
yes.
23-5 order. Yes, sir.
Filed on behalf of the respondent. All right.
On 59. Item 36.
Yes,
Lordship, first one, we have approached against order of the Honorable Central Administrative Tribunal, Lordship.
yes.
Lordship, pursuant to a disciplinary proceeding, a penalty has been issued against the delinquent, Lordship. Penalty order, Lordship will find at page 59.
You are Niranjan Das.
I'm Niranjan Das. Operative portion 62. Now therefore, the President accepts the advice of the UPSC and hereby orders that 15% of monthly pension of Niranjan Das may be withheld for a period of 5 years with immediate effect. This is the penalty.
Now,
Uh,
for what?
It starts, yes,
What misdemeanor?
it starts with the charge sheet at page 78, Lordship. Disciplinary proceeding was started
Just give us 2
70
minutes.
78.
Give us 2 minutes, Mr. Counsel.
I'm sorry.
Yes.
There were two charges and a charge sheet was issued by CPMG's Chief Postmaster General Assam Circle.
Yeah.
He is the disciplinary authority, Lordship.
Yeah.
And charges are at page 80. I'll read the charges then,
Let's
Lordship.
see the cat order.
That order is at page 191. 191. Operative portion 197.
1 second. You never appeared in the departmental proceeding.
Actually,
Have you denied that?
Actually, what happened, Lordship, the order of appointment of the IO was never served on the applicant. IO and the PO, both orders were never served on the applicant. So formally, he was never communicated that a inquiry proceedings was started against him.
How is that possible?
Now he is retired.
So therefore, it was converted into the proceeding.
Yes.
Instead of section 14, it was rule 9. Let's have the CCS rules. For a person who retires, the proceedings have to be converted.
Yes.
So we have, there must be something in the pension rules for it.
There is an order to that effect, page 89.
Yes.
It gets converted under rule 9 of CCS pension rule.
All right.
There is an order.
All right. So you would have been told, no?
Yes, he never caught it.
Who was the presenting officer?
First communicated was page 172, Lord. 172 and 170.
Any person appointed to assist him?
Lordship, he never applied for this, Lord.
Then it appears to be something behind his back.
No, Lordship.
Where has he raised that plea here? That this was never, did you argue before the court that you were not served with the copy of the appointment of inquiry officer and the
Yes.
presenting officer? Where have you said that?
Page
Where have you said that?
Page 90, Lordship.
No, where has it been discussed in the CAT's order?
Gets order not discussed. Lord.
And
Pleadings.
Pleadings, it is there.
In way.
Wait a second.
does not appear to be correct.
Yes, page 50.
Page
50. Page 50. Subpara F. But it is a matter of surprise that I'm reading the last 4 lines, but it is a matter of surprise that no copy of the said appointment letter of the inquiring authority was given to the charge officer while the applicant was serving as senior postmaster Silchar HO at that period until this date.
But then charges were framed when you were in service.
Charge sheet was, yes.
He has replied.
You
I
have
have-
replied also.
I have replied.
Therefore, you would have known,
Yes.
I
you
have
would have
known that,
known that the proceeding, your application to your statement of defense was rejected.
no,
So
that,
you would have known that, no?
no, that I did not know, Lordship. After they
This
received my,
affidavit, this would not, where, have you brought on record anything to,
Lordship, in page 174, 75, Lordship is actually all the letters we are issued, he refused. Thereafter, we paper published.
174,
174, these are the letters he refused to accept.
where do we find that endorsement?
175, Lordship, refused. He's
Refused.
Lordship.
What do you have to say this?
Page 177, Lordship. This is the report of the Jarigar, as I have been directly 170, may I read, Lord? Subject and delivery of close bearing number so and so address to so and so postmaster signature. Sir, as I have been directed to deliver the above close cover to so and so senior postmaster Silchar on 18 to 25 at 13. Accordingly, I have gone to Silchar headquarters in the chamber at 13 hours, requested him to receive the say close cover, sign the letter in token of receipt. See, so and so told me that he will neither receive the close cover nor he write anything in acknowledgement slip. That is, refused to accept the receive the close cover letter.
Take that.
He all along refused to accept.
Nothing can be done.
no, this is only one part, Lordship. This is only one part, one aspect of the matter, Lordship. What happened by that time, Lordship, lot of water had flown, Lordship, and inquiry proceedings already continued against him. So I am not even relying on this ground that the inquiry proceedings was continued ex parte.
Yeah.
I'll be relying on other procedural irregularities,
What?
Lordship. There were many, Lordship. First, Lordship, what happened? The inquiry report, it was accepted by the disciplinary authority and only thereafter forwarded to me for my reply, Lordship. Inquiry report ought to have been communicated to me for my reply thereupon, and thereupon both the inquiry report and my reply
What
ought to
difference?
have been considered
What
together.
difference, which provision of the CCS rule says so? That this
15
would be,
to
this would be taken as a
15,
lapse?
15(2) of the CCA rules.
Read that.
First, Lordship, may I show the acceptance of the disciplinary authority of the inquiry report, Lordship?
No, no, first tell us the rules.
Yes.
To our understanding, it does not make any difference. Unless the rules completely proscribe it.
Uh, The disciplinary authority shall forward or cause to be forwarded a copy of the report of the inquiry, if any, held by the disciplinary authority, or where the disciplinary authority is not the inquiring authority, a copy of the report of the inquiring authority, together with its own tentative reasons for disagreement, if any, with the findings of inquiring authority on any article of charge to the government
Now,
servant.
this presupposes that inquiring authority will send the report to the disciplinary authority, who, if he disagrees, he will give a note, then give it to you for your response.
Yes.
Where have you got this? I mean, this is a new thing that I am hearing.
No, Lordship, there are other judgments also to that effect.
What?
ECIL judgment is there, Lordship, because,
ECI versus Karnakaran?
yes, Lordship.
Not at
because
all. That's on a different issue altogether.
It says
Show
about,
us any line there from there that this is a lapse.
may I read the entire provision, Lordship, 15(2)?
Yeah.
The disciplinary authority shall forward or cause to be forwarded a copy of the report of the inquiry, if any held by the disciplinary authority, or where the disciplinary authority, not the inquiring authority, a copy of the report of the inquiring authority, together with its own tentative reasons for disagreement, if any, with the findings of the inquiring authority on any article of charge of the government servant, who shall be required to submit, if he so desires, his written representation or submission to the disciplinary authority within 15 days, irrespective of whether the report is favorable or not to the government servant. It is only thereafter, Lordship.
That's what kind of, how do you read that section?
If he disagrees with.
All right, that ground doesn't exist. In next irregularity that you can point out.
Lordship, on this, Lordship, I shall produce one judgment, ECIL judgment.
There cannot be any judgment on this. Show us any judgment.
Lordship, that judgment I am not having today, Lordship.
And then how can you plead that here?
I'll produce the judgment, Lordship.
No, that is.
I
that
shall
is-
have,
If you want time, we can grant you time. There is no difficulty.
Yeah.
But then don't take it as a. I mean, you cite some judgment. ECI versus Karnakaran, we have read it so many times. We
Yes,
have
sir.
not found any paragraph saying this. Now you can't take time on this plea. If you had to rely, this was your main plank of argument. If you're not challenging
Yes,
the ex parte proceeding,
I'm not.
then perhaps this is the only ground that you would be agitating.
There are
Then you
other
must be ready with that judgment. We will provide you a copy of ECI versus Karnataka. Give him a copy. Show it to us. Very well, you're a young counsel. We'll give you some time to prepare yourself. But then you don't have a case. I mean, this opinion is very tentative. But let's see if you can find out. I don't think you will get any. Right, but please eschew from making such statements. Don't quote judgments without reading it. And if you want to cite it, you must bring it along with you.
I'm sorry, Lordship.
That's not done. Only to ensure that a young counsel gets, full opportunity of argument before this court. We are giving you time.
I'm obliged, Lord.
But then please don't make it a practice. That's
I'm
not
sorry, Lord.
acceptable to this court. You can very well say in the beginning that I am not ready, I'll take time. This court is very indulgent in granting time. All right? What is your name?
GJ Sharma, Lord.
Mr. Sharma, learned advocate for the petitioner. After some arguments, seek some more time to get ready in the matter before addressing this court. Acceding to his request, the matter is adjourned to which date?
Any date, Lord, as per your Lord.
Give your date.
Next Friday.
Next
Uh,
Friday
next-
is not
next-
possible. Next Friday.
Next.
22nd.
All right.
You are for the state. You want your appearance to be noted.
Lordship, I have given my.
Okay, just-
All right.
Item 37.
Mr. Sharma. Yes. Yes, Mr. Sharma.
Your Lordship, on last occasion, as per order, I asked to produce Lordship inspection on the basis of which the last person, ST person, Mr. Imran or Shira, whether he was appointed as a reserve category or on his own merit.
Which order are you referring to?
Lordship.
Order is. It's for wearing in J4.
When we get it.
Where is Mr. Chakravarti? Oh, but this is against all. His union. Yes, Mr. You're taken time to place on record the marks of
Lordship,
paper
Lordship.
candidate.
That
What
in-
had happened? We were not there, no? You have to tell us what.
Lordship, we have the.
Let's hear it afresh. We don't know what has happened.
Lordship, the Union of India's preferred this writ petition, Lordship, being agreed by the order passed by the tribunal by which the tribunal allowed the petition directing for his appointment. A selection notification was issued, Lordship, for appointment of junior JE, mechanical and JE workshop. 5 posts are supposed to be filled up. 4 was for unreserved, 1 for SC. Now, after this selection list of published, the respondent was selected as the 5th candidate. For 4 as an unreserved, 4th
No,
candidate
tell
as
me one thing. The distribution of posts was 3 for unreserved category,
3
1 for SC,
SC,
and nothing for ST.
nothing for ST.
Right. Then what happened?
Then his name was included in the panel. Thereafter, we received
Which
complaint
category would he hail from?
that Lordship.
That is
Lordship,
important, no?
As a, he was selected as a general.
You
But,
are.
but a common select list has been published that your Lordship find on page 16.
Just a minute.
You are was allocated. And 4 general categories, including here. And there's a 4.
4.
And there's a 4. And there's a 4.
Total 5. 4 as unreserved, 1 for SC. One thing, Lordship.
Just a minute.
No.
And we are not,
Sure.
because our counsel was not present on that day, and adjournment was sought for.
Where is that? Show us the tribunal's order.
Lordship. 147, Lordship.
147.
147.
The respondent is here.
This one is there.
Ready?
Para 5 is where it has been noted that we are not present and adjournment was sought for. It's a habitual absentee. It has been recorded. Last two occasion was also not present.
Whom are you referring to?
Our council was not present.
Counsel there before the tribunal.
Before the tribunal.
On to that's why.
Lordship, only one thing I want to point out, that we can change the panel. That provision is provided as per Master Circular, page 113.
Page 113.
113. And the relevant portion is paragraph 9 at page 115. It's a railway board circular, Lordship. Relevant portion, para 9, amendment to and representation against panel. May I read, Lordship? Page 115.
Yes.
Paragraph 9 at the bottom, Lordship. A panel once approved should not be normally cancelled if after the formation of an announcement of the panel, procedural irregularities or other defects are found and it is considered necessary to cancel or amend the such panel. This should be done after obtaining the approval of the authority next higher than the one who has approved the panel. Now, in this case also, we have obtained the approval of the authority. That will Lordship find at page 19. This is the corrected panel. Means modified panel only, Lordship is modified panel. Page 19, Lordship.
119.
Lordship.
Only 119. Page
19. Page 19.
19.
19, Lordship. This is the modified panel and his name was not included in that panel. Lordship find the last, the panel has been approved by the CMA. That approval was there and the justification for that. And the reason behind that, Lordship, the last time in 2015, when Imran Shira was appointed as an ST candidate, he is appointed on his own merit. That instruction is,
what you have said?
On the last occasion, last election held in the year 2015, when Imran Shira appeared as a ST candidate, but he was appointed on his own merit. That list is there, Lordship. Means the actual select list we could not produce, but extract from the record because the reason has been stated. We have to preserve that record only for 5 years. That provision has also been annexed here to Lordship. His name is serial number 2.
Yes, what do you have to say? Now, he must have been number 4 in the merit list.
Now, in the 5th, Lordship, page 17.
Page 17.
His name is serial number 5. As an unreserved, he was a serial number 4.
Okay, yes.
I was at serial number 4. Lordship will kindly have, first what happened, Lordship, there was a notification. Pursuant to notification, I applied. There were 4 UR vacancies. A list of eligible candidates was published. My name was there. I participated.
That we have understood.
Yes, Lordship.
You tell us about the reason. We seriously dispute and we are not in agreement with the reason given by the tribunal that it cannot be done. It's change of vacancy midway. No. That's not the reason.
A notification, Lordship, what happened? After the results were declared, after declaration of the result, there was a complaint there were two complaints by two persons. One was ST candidate, one was an SC candidate. Those persons were unsuccessful candidate, Lordship. They made the complaint after declaration of result. Their complaint is at page 96 and 97. Their complaint is at 96.
Those are irrelevant facts so far as the decision of this case would be dependent on.
Yes, Lordship. Now their submission
So
is
it
that
has not been appointed. This order has not been complied with.
No, Lordship. There is a stay, Lordship.
what happened, Lordship? There was an earlier notification in the year 2015. In that notification, there were 9 posts. That Lordship will find at page 83. 9 posts. Out of 9 posts, 7 was for UR, 1 was for SC, and 1 was for ST. Now they are trying to say that the ST candidate, he has qualified on his own merit, so he had to be accommodated against the UR vacancies, and the ST vacancy will remain. So that ST vacancy will be added up in this particular notification. Or
You have just heard him, no?
Yes.
You have read that
Then-
document also.
then- yes,
Have you given him a copy of that document?
Lordship, that is a part of the
No, the one that you have given to us.
Lordship, that is part of the petition.
That's part of it.
then my submission would be, Lordship,
All this happened because the lawyer was not there. Yes, Segan,
the WS was there.
this order has to go.
Then my legal submission would be that, Lordship. My legal submission would be that, yes, Lordship, a person, a reserved category candidate
Your submission on law would be.
on law would be that.
Legal makes the other submission illegal.
Submission on law would be that, Lordship, that the person, a reserved category candidate, he may be accommodated against a general vacancy, an unreserved vacancy if he qualifies on his own merit. But, Lordship, it will not be applicable. That principle may not be applicable if he has availed some concession or relaxation in acquiring marks higher than the reserved
Cannot be,
candidate.
no? Cannot be, because if he falls in that category, if he travels up to the unreserved category, then perhaps no concession would have been given to him or her, whoever she is.
Concession was availed by him.
What concession?
Pre-promotional training was granted to him, Lordship, because such kind of a
That is now.
Lordship,
that law is settled.
Lordship, had it been a concession in the form of,
Sri Chakravarti, learned CG.
then matter may be remanded,
Learned
Lordship.
CG,
We'll argue on-
No.
This
We are
law.
setting it aside. No remand, nothing is required now.
On this point, I have a judgment, Lordship, on relaxation and concession.
Yes.
If he, there are 24, 25, and 26, I am relying upon, Lordship.
Paragraph 25 and 26.
24, 25, and 26. It is important to, second last page, Lordship. It is important to keep in mind that the rest,
25, just read the entire paragraph.
25 I'm reading. 25. The respondents with their CTET qualification under relaxed norms would be eligible for OBC category posts, provided their OBC status is certified and recognized by the Delhi government. But such not being the case, they are ineligible for the reserved category vacancies. To allow them to migrate and compete for the open category vacancies would not be permissible simply because they have secured the CTET qualification with relaxation of pass marks meant for those belonging to the OBC category. As the respondents have not secured the normal pass marks for general category, their eligibility for the general category vacancies is not secured. Therefore, their performance in the selection examination would be no relevant in the present process. As earlier discussed, this case concerns qualification obtained with concession in pass mark. Such concession would have a direct impact on standards of competence and merit in the recruitment of.
This is, the facts are different. Here's something different. What concession was given to?
He was granted pre-promotional training. There is a provision in the railway, Lordship. There are railway board circulars also.
That's right. But was that a condition? I mean, was that the qualifying marks?
No.
If it were qualifying marks on a lesser qualifying marks for ST category, if that concession would have been availed of by that ST candidate, perhaps, yes, you would have some ground to agitate.
This,
Not otherwise.
this promotional training has a direct bearing on the marks. Had it been age relaxation or fee relaxation, we could have, Lordship.
No, age relaxation, your argument would have been tenable. But this pre-promotion.
Training was directly connected to the examination. A person who has got the training will definitely score higher, Lordship. The training was specially for that particular examination.
Whatever may be the case, this is not.
And
this
it is
no
not a,
relaxation.
and it is not a
The
case.
The candidate, the ST candidate must have secured qualifying marks for the UR category and therefore migration to the UR category.
And it was not to the prejudice of that particular person, because at that point of time, there was an ST post also. He had never hesitated that I want to go to the UR vacancy. That ST post light vacant. And even in this
The
particular.
requirement is otherwise. The person concerned could forego. The person concerned could forego, but there is nothing to say that it was not done. Anyway, you don't have a case. Let's see.
Even in this particular notification also, those ST and SC, which they wanted to keep vacant, those are still remaining vacant. It is not that that the unsuccessful complainants, they have been accommodated to that post, sub-person to their complaint. So their complaints are not fructified. It is only to my disadvantage this entire exercise was.
We have heard Sri Chakravarti learned CGC and for the appellant, for petitioners, for the for Union of India, and Mr. Sharma for the respondent. The tribunal's judgment dated 10th of January 2024 is under challenge, whereby a direction has been issued to appoint the respondent to the post of JE/WS or JE/MNP from the panel of selected candidates as mentioned in the memorandum dated 11/9/2017 bracket connection A5 17 in modification of the earlier modified result dated 6/1/2018 with all consequential benefits. This exercise was directed to be completed within a period of 8 weeks from the date of receipt of a copy of the judgment referred to above. It appears that on May 31st, 2017, a notification for recruitment of 4 junior engineers in the discipline of workshop services and mechanical and power was issued. In that notification, the distribution of the posts were as follows: semicolon, 3 posts for unreserved category, comma, 1 for the scheduled caste category, and none for the scheduled tribe category.
No, Lordship, there was 4 for UR. 4 for UR, 1
For JE/MNP post, 1 post was allocated for the UR category with no post for SC or ST. Pursuant to the notification, a written examination had been conducted. And on the basis of the performance of the candidates, including that of the respondent, comma, a select/panel list was prepared and published on September 11, 2017. Amongst the 4 successful candidates in the unreserved category, the name of the respondent figured. However, later, sometimes in September 2017, however, 8 days later, on September 19, 2017, the select list was cancelled for the reason of the post reserved for ST category was erroneously included in the unreserved category. For this error, comma, the panel list was required to be revised. Subsequently, a fresh select list was published on January 6, 2018, in which the name of the respondent did not appear. The name of the respondent figured at serial number 5. And since only 4 persons under the unreserved category, since only 4 posts under the 4 posts were earmarked for the unreserved category, comma, the name of the respondent had to be excluded. This change in the select list was challenged by the respondent through OA before the tribunal. The grounds urged on behalf of the respondent was that once a select list was prepared, comma, it could not have been changed or altered to the disadvantage of the respondent. Acceding to the arguments raised on behalf of the respondent before the tribunal, arguments raised, comma, the tribunal concluded that no change could have been made with regard to vacancy or otherwise if the examination was held as per the terms and conditions of the notification, without cancelling the notification in the first instance. The tribunal also held that when the notification in question was in existence, in which there was a specific mention of 4 unreserved vacancies and 1 vacancy for SC category in the post of JE/WS and JE/MNP and JE/WS and JE/MNP, and no ST vacancy against 5 vacancies of JE/WS and JE/MNP, then even if there was any mistake in the calculation or earmarking of the vacancies, comma, the only way out for the authority was to cancel the notification. Under no circumstance, comma, the CAT concluded that in the midst of the recruitment process, comma, the vacancy position could have been changed. The Learned Counsel for the Petitioner/Union of India submits that the decision by the tribunal was passed in the absence of the counsel, and that the reasoning given by the tribunal was not correct. It was no midway change, but it was no midway change, comma, according to the Master Circular number 31, in connection with promotion of non-gazetted Group C staff to selection posts, it has been provided that a panel once approved should not be normally cancelled. However, if after the formation of an announcement of the panel, procedural irregularities or other defects are found, and it is considered necessary to cancel or amend such a panel, that could be done, but only after obtaining the approval of the authority next higher than the one who approved the panel. In that case, representations, if any, against a panel would be submitted to the competent authority within a period of 2 months from the date of announcement of the panel. The authority that approved the panel or higher authority could use his discretion and take such action as is considered necessary, subject to his satisfaction that an irregularity had occurred, and irregularity had occurred. In fact, what had happened was that amongst the 5 persons amongst the, in fact, what had happened was that one candidate of the ST category had migrated to the unreserved category for the reason of his performance. Precisely for this reason, the vacancy position for unreserved category was left to number 4 only. Since the respondent was at serial number 5, his name had to be excluded. His name had to be excluded. This aspect of the matter has not been gone into by the tribunal. In fact, the has not gone into of the tribunal. The change in the vacancy position on the basis of amendment made in the selection list was permissible under the instructions / circular relevant for the purpose. Relevant for the purpose. For the aforementioned reason, we find the order impugned by the tribunal to be lopsided and not sustainable in the eyes of law. We therefore set it aside as a defend in the SLA. But defending the decision of the CAT, Mr. Sharma and counsel for the respondent drew the attention of this court to a decision of the Supreme Court in Government of NCT of Delhi and others versus Pradeep Kumar and others. Bracket civil appeal number 8259 of 2019. Bracket arising out of SLPC number 11254 of 2019. Wherein it has been held that if a candidate under relaxed norms under relaxed, what did I say? The number so and so, First, we have only said in which it was held that any person having availed of concessions under the reserved category could not migrate to the unreserved category. We are constrained to observe that the facts in the facts of the case in Government of NCT, Delhi and others versus Pradeep Kumar and others, Supra, was different. Even otherwise, the candidate, the candidate of ST category who migrated to the UR category had not availed of any concession for any special category, except for having received or undergone a pre-promotion training. In that view of the matter, we find the order of the CAT to be unsustainable in the eyes of law, and therefore we set it aside. the writ petition is allowed.
Item 38.
Yes.
For the respondent lordship in this case,
Who appears for the petitioner?
Ms. KJ in the.
Nobody appears on behalf of the petitioner. The counsel for the central government is present. Re-notify, 3 weeks.
10-9. Item 42.
May it please your lordship, Malab. Malab, here Malab petitioner is sale, Malab, the order dated 3/10/2025 at page 116, Malab. That is passed by the learned Armed Force Tribunal, Malab.
Yes, 1 minute.
Sure,
Just have a look at the order.
my.
It's the service tenure is.
4 years. Malab, Malab, one thing is admitted.
Very, very harsh.
Yes, Malab, that's what, Malab. That's what. Malab, moreover.
You should have challenged that rule.
No, Malab, rule, Malab, that my submission is that wrongly read, Malab.
Wrongly
That-
read.
Yes, Malab, kindly say page 83 is the rule.
Page?
83, Malab. That is my submission before your lordship, Malab.
while my lord, considering the law as a whole, the learned tribunal failed to, my lord, to read and understand this rule, my lord. Page 83, kindly have a
Just a minute.
note, my lord.
This is not rule. This is a policy.
Yeah, I'm extremely sorry, my lord. It's a policy, yes, my lord. My lord,
Just a minute, just
sorry,
one.
sorry.
Detention for additional
Yes.
training and release of Agniveer during training at centers. Yes.
My lord, here, my lord, page 83, in between, my lord.
No, this is for additional training. Original training. What?
No, this is the, my lord, on the basis of which they have, my lord, access the power.
All right, yes.
Note kindly see, my lord. Sunday and holidays observed by the training centers.
Where are you
Absence,
reading?
my lord. 83. Page 83, middle portion, note, my lord.
No, read from top. Grounds for detention. of
Grounds for
additional training at
detention for
centers.
additional
Agniveer may be
training.
detained at training centers
Yes,
for the following:
my lord,
failure in mandatory test, missing training.
missing.
So
Even,
this is maybe detained, but he cannot be discharged.
yes,
So where is the provision for discharge?
this is for that purpose, my lord, they exercise power under Army Act.
Where is that provision?
Yes, my lord, 13(3), yeah, my lord.
No, you're referring to which act? Armed Forces Tribunal Act.
My lord, in the impugn order, they have referred to, my lord, the Army Act.
Army Act.
Discharge order is lordship find at page 48, my lord. Discharge from service for missing training 30 days under
Page
provision.
58.
Yeah, rule 13(3), item 4 of
Yeah.
Army Rules, 1954. my lord. Now, from the table also, my lord.
Where page 48? Discharge certificate.
Yes, yes. Serial number to service particulars, then my lord, discharge from service for missing training more than 30 days under the provisions of rule
13(3).
13(3), item 4. Item 4 has been taken from the table, my lord, from the rule. My lord, there in the table, rule, table, my lord, 4,
Army
it is.
Act 1950, section 13. I don't think.
Rule 13, rule 13.
Rule, I mean, yes, my lord, rule, my lord.
Rule 54, 54 rules.
No,
Yes, 1954 rules, my lord. Rule 13(3).
(13)(3) lists the authorities who are empowered to authorize discharge.
Yes.
And what is the ground?
From the table, my lord, rule 4, my lord, 4 kindly see, they have also indicated item 4 from the table and the right hand side, my lord. Manner of discharge in the case of person requesting to be discharged before fulfilling the conditions of the enrollment.
Which page?
My lord, page, my book 56, my lord. From the table appended to the rule 13(3), my lord.
No. Manner of discharge we have
Yes.
seen, but which category?
That's the last part, my lord, person, second column, my lord. 4, grounds of discharge 4, all classes of discharge, commanding officer, then my lord, the manner of discharge kindly see, my lord. In the case of persons requesting to be discharged before fulfilling the conditions of their enrollment, the commanding officer will exercise this power. My lord, I have never.
Your last one.
Yes, last one.
Last one. Tell us that. So many. In case of persons.
Which page? 59.
60. That this table now, 13 table.
Yes, I have never requested, my lord,
In case of person-
for discharging.
Maybe the wrong word header.
And
Maybe that part of that.
and
Continuous 21, consecutive 21. but pending it. Up to maximum 30 cumulative. Okay, 21 must be consecutive.
my lord, one submission is
Yes, yes, what do you have to say?
Well, here, well, as per the policy, my lord, of
What
the
is the policy?
Agniveer, my lord. But specifically in the, it is indicated that if a person is continuously absent for more than 30 days, he is liable to be released, my lord. So accordingly, as per Army Rule 13,
Policy
3,
has wrongly been read.
yes. My lord, this hasn't done, my lord. And there is no information in the being order passed by the Government Tribunal.
That's not the policy. Take a, who were the party? So item number 42. This item number 42 is Mr. P.K. Das from the team. We have heard Sri P.K. Das, Land Counsel for the petitioner, and Mr. U.K. Goswami, Deputy Solicitor General, Deputy SGR, Deputy CGC. The petitioner, the discharge of the petitioner, actually. The discharge of the petitioner by order dated 12/4/2023, passed by the competent authority, and his prayer for allowing him to continue as Agniveer in the Indian Army. What have I said? We have heard so and so. The for the discharge of the petitioner from the position of Agniveer has not been interfered with by the Armed Forces Tribunal, Regional Bench Guwahati. His request for allowing him to be continued as Agniveer of the Indian Army also has been refused. The petitioner had joined the Indian Armed Forces as Agniveer, bracket general duty, in the Armored Corps, Ahmednagar, on 27th of January 2023. While undergoing basic training at Ahmednagar, he had suffered serious knee injuries on 8th of February 2023. He was admitted to the military hospital at Kirki for treatment and remained under medical care at the military hospital from 8th February 2023 to 13th February 2023. And later, from 13th of March 2023 to 21st of March 2023. For the period between 13th of February 2023 and 12th of March 2023, the petitioner was prescribed rest by the attending doctors, which would be evident from the discharge slip dated 13th of February 2020. He appears to have reported on duty on 21/3/2023, when the commanding officer allowed him to resume his training. However, later, by order dated 12/4/2023, the petitioner was discharged for missing training for more than 30 days under the provisions of Rule 13(3), item Roman 4 of Army Rules 1954, and as per para 9B of HQARTRAC, letter number 10010/cat-B-B/training TRG B dated 17th of November 2022. You can take this from page 48. This order was challenged by the petitioner before the Armed Forces Tribunal. The tribunal on perusal of the relevant rules concluded that even with respect to illness/admission in hospital or sick leave, an Agniveer could be discharged for having missed out on training. The Land Council for the petitioner has submitted that in fact the rule in question has wrongly been construed by the tribunal.
Absence due to organization activity or any other reason beyond the control of Agniveer has not been considered. Page 120 rule.
Misunderstood. According to the policy for detention for additional training and release of Agniveer during training at centers, it has been provided that if an Agniveer misses more than 21 consecutive and up to maximum of 30 cumulative days of training during the entire training duration, owing to any reason, he/she will be given additional training up to 4 weeks so as to complete the training schedule. Individual missing for more than 30 days of cumulative training for any reason will be liable to be released for calculation of 21 consecutive/30 cumulative days of missing training. The absence period would include admission in hospital, sick leave, absent without leave, /overstaying leave, if special leave is taken, and excused physical activity and organized training activities, bracket each day accounting for 25% absence, dash, that is total of 84 consecutive / 120 cumulative days. Which page were you referring to?
That come to judgment, it's a 120 page, Milo. Note I was referring, Milo. That is
83.
No,
note. Yes,
what is it?
120 page, Milo, middle, Milo, from the middle, note. Milo, it is from the policy itself, Milo. The learned tribunal. Milo, Sunday and holiday observed by
A
training
special-
centers.
A special provision has been
Yes.
made that Sundays and holidays observed by the training centers
Absent.
and absence due to organized activities or any other reason beyond control of the Agniveer will not be counted towards training period thus missed. The tribunal, though, took note of that policy, but did not consider did not note appended in the policy and held that since the absence from training period was for more than 30 days, comma, the petitioner was liable to be discharged. The relevant provision of dismissal, discharge, etc. is provided under chapter 3 of the Army Rules of 1954. From the table appended to Rule 13 of the Rules of 1954, prescribes that in case of persons requesting to be discharged before fulfilling the conditions of their enrollment, comma, the commanding officers will exercise the power of discharge only where he is satisfied as to the desirability of sanctioning the application, that the strength of the unit will not thereby be unduly reduced. Recruits who are considered unlikely to become efficient soldiers will be dealt with under this provision. Neither the petitioner had prayed for discharge, nor had he missed out on any additional training. In fact, the authorities were aware of the fact that while on training, comma, he had received knee injury for which he was hospitalized. Later, again, under medical advice, comma, he remained in the hospital under rest. Stop. Had it not been known to the authorities, and the authorities would not have had it not been known to the authority, comma, he would not have been allowed to rejoin his duties. The contention on behalf of the petitioner is that the tribunal did not take into account the note appended to the policy which provided for absence because of unforeseen circumstances or circumstances which are beyond the control of the trainee. The tribunal, on the other hand, found that if at all the petitioner was aggrieved by the order of discharge / release, he should have challenged the policy. The land council for the petitioner therefore submits that the decision requires a relook, especially with respect to the note appended to the relevant part of the policy dealing with discharge / release of a trainee for his absence from the training period. The moot question which ought to have, the question which ought to have been considered by the tribunal, namely whether the absence was willful
Yes.
or whether the trainee / petitioner was malingering / feigning illness. What have I said? First line? Malingering or feigning illness. First off, in the absence of any such finding, the decision to discharge the petitioner from Agniveer ought not to have been sustained. Ought not to have been sustained. Next. Training is compulsory, especially when the duration of such training is short, especially in cases of Agniveers whose tenure is only for 4 years. Notwithstanding this, since the petitioner was under medical care in the military hospital, which was in no of the authorities, and the authorities had the commandant had permitted him to rejoin, there was no reason why he should have been discharged. We therefore have been persuaded to set aside the order impugned and remit the matter to the tribunal again.
My lord.
Set aside the order and direct the concerned authority to allow the petitioner to resume his training. At the earliest. The decision in that regard shall be taken on the receipt of the production of a copy of this judgment before the concerned authorities. The petition stands allowed to the extent indicated.
My lord, may I make one submission, my lord? I'm obliged that lordship has allowed this, my lord. And moreover, my lord, para 16 of the writ petition, I stated that he could not get any job, nothing, my lord. He was frustrated.
That is compassion we are not taking.
Yes, my lord.
We are
For
taking your
backpage, I
legal
was,
ground.
my lord, trying to, my lord. Deeply obliged, my lord, deeply obliged.
For hearing, item 45.
Lordship, I'm here for the respondent.
45 by paper. Yesterday evening, Lordship, they have appointed me the senior counsel of the university due to recent progress, Lordship. That's why Lordship may accommodate me.
So the council has traveled to this side.
Lordship.
But you are there. Anyway, you want accommodation.
Lordship, being only with them.
You have been engaged yesterday. What's your name? You have just appeared. Mr. K. Goi, learned advocate for the, and the appellant submits that he has been engaged in this matter only yesterday after the earlier advocate having been elevated to the bench. He therefore seeks an accommodation. Let this matter be listed under the same heading on after 3 days. After 4 weeks.
Lordship, I
11-9.
mention to list this matter, your lordship, to apply the honorable court for non-compliance of the order to the 21-5,
Let's see, the lawyer must get ready in the brief, no?
because my pension has not been paid, your
So
lordship.
after
In spite of the categorical order of this honorable court on 21-5-2020,
all right, we'll see. On the next date, please come with all matters.
because that has not been paid, your lordship.
It is paid, it's but written instruction, lordship. I have the instruction here. After going to the order yesterday evening, lordship, last order, I have asked the registry. Registry says the lordship, up to June, he has paid, lordship. I have the document, I will submit next month.
Only provisional pension has been paid,
On the
regular
next day.
pension has not been.
11
paid, your lordship.
September.
Obliged, lordship.